guys, welcome back. Today I want to talk about 4 landmark cases that often come up with retaliation claims. These cases set legal standards that EEOC and the courts use to decide if what our employer did to us was retaliation. They're foundational to many legal arguments in this space, and understanding them can help you build a stronger case, whether you're talking to EEOC, the courts, your attorney, or whoever. I'm going to walk through these one by one, and as I go through, I'm going to share key findings in each case, as well as how the courts use them to evaluate our claims, how we might cite them to prove our claims, and how our employer might cite them to push back against our claims. Now, I'm not an attorney, so you're not going to want to use any of the examples that I share today verbatim in your own case. Your arguments need to be tailored to your facts and your evidence. But I do want to give you an idea of how these cases can be used to shape legal arguments on both sides. And to make it easier for you to follow along today, I'm going to be putting a lot of stuff on the screen, and I will put as much of it as I can in the description as well. And in the description, I will also link to these cases at Google Scholar so that you can go out and check them out for yourself. So let's dive into the first case, Burlington Northern and Santa Fe Railway Company versus White. This case expanded the definition of adverse action and therefore retaliation, and it also applied the reasonable person standard when evaluating retaliation cases. Here, the court found that any employer action that might deter a reasonable person from participating in protected activity could be considered retaliation, even when there's no financial harm. But this case also says that petty annoyances and minor inconveniences don't rise to that level. And here's an example of how it might be cited by the courts. Under White, the adverse action need not be a termination. Any materially adverse action that would deter a reasonable person is enough. Here's one way it might be cited by us, the plaintiff. My transfer was materially adverse under Burlington Northern because it would deter a reasonable person from filing a complaint. And finally, how our employer might use it. Burlington requires a materially adverse action, and what we did doesn't meet that threshold. The next case is University of Texas Southwestern Medical Center versus Nassar. This case sets the but-for causation standard for private sector retaliation claims. So in the private sector, workers have to show that their employer wouldn't have taken the adverse action against them but for their protected activity. And that's a high bar. Now let's look at a few quick examples of how it might be cited. By the courts, as Nassar requires, the plaintiff must demonstrate that retaliation was the but-for cause of the adverse action. By us, although my employer points to performance issues, Nassar allows me to show those are a pretext for retaliation. And by an employer, Nassar requires the plaintiff to prove retaliation was the sole cause of our decision, and they haven't met that burden. Now, Nassar doesn't apply to federal workers. Instead, federal workers will want to cite to the statute, 42 U.S.C. section 2000E-16A, which says federal personnel actions must be free from any discrimination. And under this statute, federal sector workers only have to prove that retaliatory intent was one reason for our employer's actions. We don't have to show it was the only reason or even the main reason. Clark County School District versus Breeden. Here the court decided that very close temporal proximity between our protected activity and our employer's adverse action can support a reasonable inference of retaliation, even if it's the only evidence we have. And here are some examples of how this case might be cited. By the courts, the short time frame between the complaint and the adverse action, consistent with Clark County, supports an inference of causation. By us, the plaintiff, Clark County suggests that the close timing between my complaint and my suspension is enough to suggest retaliation. And by the employer. Unlike Clark County, several months passed here, making it unreasonable to infer a retaliatory motive from timing alone. In the case of McDonnell Douglas versus Green, the Supreme Court established the burden-shifting framework for analyzing not just retaliation claims, but discrimination claims, when we don't have direct evidence of our employer's retaliatory or discriminatory intent, but we have to rely on circumstantial evidence to prove those things. It works like this. First, we have to prove the prima facie elements of our discrimination or retaliation claims. And then our employer has to articulate a legitimate non-discriminatory reason for their actions. And if they can do that, the burden shifts back to us to prove that the reason they gave is just pretext. Here's how you might see that case cited by the court. Applying the McDonnell-Douglas framework, the plaintiff has established a prima facie case, shifting the burden to the employer. By us, the evidence is sufficient to prove the elements of my prima facie case, and under McDonnell-Douglas, my employer must now articulate a legitimate non-discriminatory reason for their actions. And by our employer. Even assuming a prima facie case has been established, McDonnell-Douglas allows us to rebut it with a legitimate non-discriminatory reason for the decision. If you bring a retaliation claim against your employer, chances are you're going to see these 4 cases referenced in your court's decisions, legal briefs, and motions. And if you're working your way through the federal sector EEO process on your own, or if you're pro se in federal court, you're going to be expected to know and understand the standards set by these cases. And really, these are essential reading for anyone who has a retaliation claim. So I'm going to keep it short and stop there for today, but in the description I will link to these cases at Google Scholar so that you can go read them for yourself and check out some other cases that have cited these. Now, over the next few weeks, I'm going to be doing this same kind of thing with other types of retaliation, so if there are particular types that you guys would like me to talk about, let me know down there in the description. Otherwise, I will see you guys next time. Till then, take care and hang